Hi friends, once again I Sunil Gupta welcome you at the platform of Inspiration IAS Academy. This platform is going to provide quality education particularly for those aspirants who are in the preparation dedicatedly for the civil services, right? So today in the series of the PYQ discussion, I have taken the some question from the previous year questions. Now this time I have taken the question from the 2023 Indian Polity and Governance, right? And then I will make the discussion elaborately one by one, right? But before going through the discussion, I would like to share you some of the important facts. Our discussion will be divided into two parts. The first is called the content conceptualization part, and second is called the answer presentation part. Right? What does it mean? It means the first important area, content and conceptualization. I will just make the discussion about the issue related to the question. Just like for example, today I am going to discuss the question related to right to privacy. Right now, just like this question I will discuss today. This question is being asked in 2023 this year, and this question is related to right to what is called the right to life and the personal liberty. Same question having the same orientation is being asked in 2015 earlier, right? So I would like to tell you that I will just make the discussion about right to life and the personal liberty and the context. It is not related to the space management. How to mention these particular information in 150 words or the 250 words. Space management is a part of technical aspect depending upon your skill. We will have to make the discussion under the answer presentation part. So first important area, we will have to make the content discussion. Content discussion means I will give you the information related to the topic, right? Topic not related to complete the question, it is related to what? The topic here, right? I will tell you the topic, right to privacy, right to life, right to personal liberty, scope, that is related to the question is concerned, right? Second important, we will have to focus upon conceptual framework, right? Conceptual framework. Conceptual framework means there should be the idea about the topic with the mental map so that you can understand each and everything appropriately for the examination. If the question is being asked and repeated in the another year, you will have the complete preparation for the writing the answer, right? And second important portion is answer presentation, in which I will have to make the discussion how to present under the three important basic structure. What is called the introduction. How do you like to present the answer in under the introduction? What should be the introduction? Because introduction should not be more than 10% of the allocated word limit. If you have to write in 250 words, it is expected your introduction should not exceed to 25 words. 25 to 30, it's okay. But if you are going to write in 50 words, or you are not going to write even the 10 words, then it is highly unexpected way of presentation. I will discuss you what is the introduction under this question, right? Second, we will have to make automatically main body. So main body, you know very well. Main body, the basic information we will have to put under the main body. If information is more and you have to present in the very small structure, what kind of techniques you have to use for the presentation? Will you write in the point-wise approach or will you write in the paragraphic approach? How do you like to manage the fact and analysis? We will have to make the discussion under the this main body. And the third, what is called the conclusion, right? So conclusion, very well, three important areas. You have gone through so many YouTube videos. So you have idea about, introduction, main body and conclusion. Conclusion is very, very important effect on the examiner. Basically, there should be the way forward. There should be the some suggestions related to the issue. And if the issue is very debatable or the you can say very optimistically in nature, then at that particular time the conclusion needs one orientation, and this conclusive orientation should be based upon your complete analysis based upon the discipline orientation, right? So based upon this, we will have to make the discussion under three important areas. So it is very clear. First, we have to go through the content, then conceptualization, answer, presentation. This is the general discussion based upon the topic, so that if the same question is being asked in the another year, then you will have the comfortable for this, right? And this is completely related to the question prescribed under the discussion. That's clear. So I think you are the very clear about each and everything. Should we go now? Go. So it's okay then. So let us go for the question. Question is here. This is being asked in the 2023 under the GS paper 2, question number 11. That is called this one. The Constitution of India is a living instrument with capability of enormous dynamism. It is the Constitution made for the progressive society, illustrate with reference to the expanding horizon of the right to life and the personal liberty, right? This is basically the comment. This is the Constitution of India, the living instrument of capability. This one is concerned, and this is basically the comment. And based upon that, we have to say the illustrate with a special reference to expanding horizon of this one, right? First, many persons are going to explain the answer without going to understand the basic demand or the core demand of the question. Now tell me, what is the demand of the question? Demand of question is you have to write dynamics of the Constitution of India. Demand of question is you have to just make the expanding horizon of the right to life and personal liberty. Whether you have to write Article 21, right to life and personal liberty, or you have to mention the dynamics portion of the Constitution of India. What is basically the demand of the question? Many persons have made the mistake in such a way. Some person has to just describe living instrument. Then they are going to write living instrument because this one, that one, modernization doesn't matter. Second important dynamics. Dynamics change orientation is going to happen. Progressive society, many persons are going to write, and they are going to forget to write right to life and personal liberty. Right? So what do you think about it? First, catch the region of demand, and then you have to catch the point of demand. Clear? So region of demand, this question is not related to the dynamic character, or you have not to explain the dynamism of Constitution of India much more, but you have to concentrate upon this one, illustrate with a special reference to, because this is mentioned a special reference to expanding horizon of right to life and personal liberty. Means the locus, the question is being asked from the region of right to life and personal liberty. And under this one, what is the point of demand? Basically, two important point of demands are there, right? And so the first is there, a scope expansion of right to life. It has to say that our constitutional makers have given right to life and right to personal liberty. These two rights clubbed under Article 21 of the Constitution of India. This right has been expanded, and so why expanded? Because our constitution is dynamic in nature. Our constitution accepts modern positive state. Our constitution has to incorporate progressive nature of the social system. And for this particular purpose, the horizon of the Article 21 is getting expanded from the time to time. Basically, one case is the very famous in this way, and that particular case was the Maneka Gandhi case that was introduced in the 1978. Supreme Court adopted modern doctrine. This is called the doctrine of due process of law. And after inception of this doctrine, many change-oriented character of the social system leading towards progressive society were incorporated by expanding the horizon of right to life and the personal liberty. So, what automatically, basically two important demands are there. The first important is scope expansion of the right to life, and second important scope expansion of right to personal liberty. right? Though important rights are there. Now, these particular scope expanded, and so we have incorporated what? Progressive social system, progressive Indian society, right now, and progressive Indian society, and so this is nothing but is a part of the dynamic character of Constitution of India, right? Character of Constitution of India. So based upon that, we have to go through the analysis, and our discussion will be based upon two important, elaboration: a scope expansion of right to life, a scope extension of the right to personal liberty. Any doubt? No? So let us go for the discussion. The first important conceptualization, right? Conceptualization is there. I would like to say, some important portion under the conceptualization is what, right? That is, first you should understand what is called the right to life and personal liberty. Right to life is another important portion, and another important right to personal liberty. Personal liberty. These two rights are mentioned under Article which one? 21 of the Constitution of India. Right. This is two rights clubbed under the Constitution of India. Understand what is the right to life? Right to life means this is the Indian citizen or the any person and the land of the citizen, land of India. Then this person has right to life, having two aspects. First, a state will provide all inputs that is essential for the life. Also, second important, a state will not make any kind of the public policy that is going to compel the person to suicide. हम वो सब कुछ प्रोवाइड करेंगे जो जीने के लिए ज़रूरी है, और हम वो कभी भी ऐसा पॉलिसी या लॉ नहीं बनाएंगे जो आपको मरने के लिए मजबूर करता हो. दिस इज कॉल्ड द राइट टू लाइफ. दैट्स क्लियर. Say, what is the right to public? This is the personal liberty. Right to personal liberty is very clear. Consider this is the human being. You are also the human being. And you are the multidimensional person, multidimensional animal. Human being is a multidimensional in nature, because human being is the social animal, economic animal, political animal. You have the political ideology, you have the social ideology, you have the social system. So you have the many information of the caste, which caste you belong, which region you belong, which religion you belong, which political orientation you have to follow, right? What kind of the family you have. Many information, you have lakhs of information is going to happen with the human being. And there are two domain. Two domain is there. One domain is said to be what is called the public domain. Public domain. So, and one is called automatically the personal domain is concerned. Personal domain. You can put information either in public or in what? Personal. Just like your name. Your name is the public information. Every person has to know your name. Right? But your caste. The caste may be personal, may be public. Right? So whether information should be kept under the public or the personal, depending upon what? Depending on the person. This is the personal liberty to take the decision whether I have to put my information whether in the public domain or the private domain. Private domain will be accessed by only you, but public domain may be accessed by the any person. So this is your personal liberty. Consider you do not want to make your caste public, then you have to put under the personal, right? But if anyone has to compel you, no, you have to tell your caste. Then if such kind of, the force is against the right to the personal liberty. So you know very well what is the meaning of the right to life and what is meaning of the right to public personal liberty, right? Now, first important, understand right to life and right to personal liberty, you understood, clear? Second, you have to understand the differentiation between two important doctrines. Doctrines, that is the two important doctrines. You have to just, make the discussion under the two important doctrines here, right? I'm just giving you the small scale of this one. Doctrines. Doctrines may be of two types, right? One is called doctrine of procedure established by law. Procedure, established by law. by law. Procedure established by law is the doctrine that has to say that what kind of a state will provide you information. I told you, na, right to life means a state will provide all information that is essential for living, essential for the life, right? If any person has to say here, sir, I need cocktail, right? And brand is the Johnny Walker, right? So do you understand a state will provide cocktail, Johnny Walker? No. A state will provide all information, all inputs that is related to the life, right? But if the person is going to demand unnecessarily or outside the basic life, the state will provide each and everything. No. Doctrine of procedure established by law has to say what is the limitation of providing inputs by the state that would be decided by the state, decided by the procedure established by law. Law will be made by the state. So parliament or the public policy will just give you the limitation, I will provide you this one, cocktail is not being provided to you, right? So this automatically jurisdiction of the life is decided by which one? That is the state, and so this is called the procedure established by the law. यहाँ पर स्टेट डिसाइड करता है बच्चे कि तुम्हारा जुरिस्डिक्शन क्या होगा, किस किस इनपुट्स को तुम्हें हम प्रोवाइड करेंगे, राइट? तो this doctrine has been taken from which particular? That is called the Japan. Japan से हमने लिया था. Our constitutional makers have to say कि procedure established by law is the basic doctrine. I will give you the right to life or the personal liberty based upon procedure established by law. Our original constitutional makers have mentioned here. But America is not going to follow this concept. America has to say, consider, a state is not going to provide me this input, although this input is necessary for justice. So at that particular time, justice is important or a state is important. I feel the justice is important. And so America is not going to tell procedure established by law. We have to say, this is called doctrine of due process of law, right? Due process of law. Due process of law has to say the jurisdiction is decided by a state. No, jurisdiction is decided by the justice system. If anything is very justified for the life and personal liberty, it should be placed under this particular domain. So domain must be demarcated by the justice mechanism, not by the state mechanism. So justice is more important than the law. And so it has to say here, which one has to dominate in the system? Justice should dominate in the system. This is the doctrine we are mentioned under, what? This is the USA, right? Our constitutional maker in 1950 accepted the doctrine of what? Due process. This is the procedure established by the law. But state was very insensitive on the certain justified matters. And so, ultimately in 1978, one case came into being. This is called the Maneka Gandhi case, right? Maneka Gandhi case. Maneka Gandhi versus Union of India case, 1978. And under this particular case, Supreme Court accepted the doctrine of the due process of law, American doctrine of due process, and had to see a state is not the whole and sole mechanism to take the decision of the jurisdiction of the domain, boundary of domain, but who will decide? The state will not decide, but automatically justice system will decide. If anything is justified and the state is insensitive towards going to put that particular matter under the jurisdiction of the domain, then judiciary itself has the power to put under this particular jurisdiction, right? And after inception of this one, the expansion of Article 21 is getting started, because many unjustified components were there, and these were not incorporated under the fundamental right. And so Supreme Court later interpreted, and then it has just, make the horizon of right to life and personal liberty much more. That reflects the orientation of the progressive social system. And this is basically the demand of the question here. That is, what is the expansion is concerned, the expansion, scope of expansion is leading towards progressive Indian social system and the dynamic character of the society, right? Now, I think it is very clear about your scope. You should understand two important things: what is the right to life and the personal liberty, and what is the difference between doctrine of due process of law and the doctrine of procedure established by law. That's clear. So let us go for the discussion on the question, and the question is what? Ki the expansion, this is the question basically, that is the expanding horizon of the right to life and personal liberty, right, that is leading towards the progressive Indian society and the dynamic character of the constitution, right. So let us go for how the expansion has been taken place. I would like to tell you something with the help of this PPT, right. See, what is going to happen in the expanding character of social system expanding? I would like to change, this one. So first important area is there, expansion, expanding a scope of right to life, right to life. And in next, area, we will have to go for, this is called right to privacy, right, expanding character of what? Right to personal liberty, personal liberty. The first, you have to go through the right to life, and next on, we will have to go for the, personal liberty, right. See, after Menka Gandhi case, basically, right to life is getting expanded. How? These are the aspects. The first important is called right to live with dignity, right? Right to live with dignity. I'm just telling you. Right to live with dignity, right against sexual harassment, right to clean environment, right to shelter, right to end of life choice, and right to abortion. Basically, these are the important areas, although many expansion has been taken in the many aspects of the expanding scope came into being. But these are the basically the core area where the expansion is very, very important here. And so let us go for the discussion of the each and everything one by one. Right? I think everything is visible here. Right now? See, first important, right to life with dignity. Right? Right to life means life is given to you. I will provide you all inputs that is related to the living human being, but with dignity or without dignity. आपने जिंदगी दिया देने के लिए तो डिग्निफाइड वे में कि इनडिग्निफाइड वे में, राइट? नो, you have given the right with dignity. That is going to happen under the Menka Gandhi case 1978. Explicit Supreme Court has to say that right to life does not mean right to have quantitative life, right to have the qualitative life. Life को हम quality form में जिएंगे, not in the very quantitative form, right? So you have to live your life with dignity. And for this particular purpose, in order to maintain the dignity of the social system, there should not be any presence of child labor. There should not be the presence of any exploitative mechanism. Although exploitative mechanism has been eliminated because right against exploitation itself is the fundamental right, but still, if any form of the exploitation is going to happen in invisible order, then it will also be, so automatically eliminated from the system. Child labor, although Article 24 has given the, fundamental right, we will have to just, prohibit the children employment in hazardous industries. But still the child labor is going to happen, then it is not a part of the system. This is against the dignity of the human being. After Menka Gandhi case, this particular system has been given a parliament, accepted and enacted Child Labor Prevention and Regulation Act 1986. This has been amended many times. In the 2016, we have taken the decision that the children employment in all processes are banned. All processes are illegal, right? So this child labor is getting automatically eliminated only to maintain the dignity of the human being. Same thing is there, manual scavenging. Manual scavenging itself is a part of the very indignified profession, but it was going to happen in the social system. So Parliament later on automatically amended this particular and enacted the Manual Scavenging Act 2023 and has taken the decision right from today this particular kind of the manual scavenging must be eliminated from the social system. This is the social blot up on the Indian society. This has been a part of the hindrance in the progressive social system, and so has to say it should be eliminated, it should be stopped, right? Second is concerned right against sexual harassment. Very important case, what is called Vishakha guidelines in 1997. Vishakha versus state of Rajasthan case 1997 was there. Under this one, Bhavri Devi case. Bhavri Devi, that is one of the important social activists who sacrificed her life for this particular purpose. And so, what is the nature on Vishakha guidelines came into being under the Supreme Court judgment, and it has to say many regulations were incorporated on the industrial organization that you are going to follow the particular committee system and you are going to maintain the record of the each and everything for the maintaining the dignity of women. And so this is the Vishakha guidelines 1997 came into being. Second important is that with Sexual Harassment at Workplace Prevention, Provision and Redressal Act 2013 came into being. That was nothing but legalization of this particular judgment under this particular act. This perhaps would not have been taken place if there would not be the expansion of Article 21 in matters of right to life, right? The third expansion came into being, what is called the right to clean environment. Although environment itself was neglecting feature since independence, but later on environment has become the very, very important aspect. Pollution has become the very important, aspect of the life. And then and thereafter, whenever the pollution is there and the many persons are going to lose the life, just like air pollution is going to, even in Delhi is concerned, pollution is going to happen, and sometimes Delhi has become blackout due to the impact of the pollution, right? And for this particular purpose, if a state is still not sensitive towards the eliminating, this is automatically prevention of such kind of the polluting mechanism, then automatically a state has to come forward. In this way, the Supreme Court came into being, and one very important case, MC Mehta versus Union of India case 1986. MC Mehta cases are much more. Even the many cases are going to happen in 2000 plus. And so these are related to clean environment. You have to maintain the preservation of the environment. And for this particular purpose, you have seen, in order to fulfill the obligation, now Parliament enacted Environment Protection Act 1986, and in order to just make the redressal grievances, and then NGT Act, National Green Tribunal Act 2010 came into being. Under this, National Green Tribunal were constituted, and then and thereafter this has been given the authority to take the decision for the clean environment. So you have seen these are the initiatives taken by the state only under the expansion of Article 21 of the Constitution, right? Let us go for the another important portion of discussion, and this is called the right to shelter, right? Right to shelter is there. Right to shelter is the next important area, right? Right to shelter. Right to shelter means every person should be given automatically shelter right. Shelter. Shelter, I am just giving you this one so that you can be very visible about it, right? So let us go for here. Right to shelter. Right to shelter means everyone should be given the house. This is not dignified life. Many persons are living on footpath. Many persons are living in open sky, even in the winter season. We are going to use the kambal and then jackets and the sweaters and so on, and some persons are in the footpath. No, this is not a part of the welfare and progressive social system. There should be the right to shelter. All the persons should be given the sheltering. Roti, kapda and makan is said to be. Makan itself is a part of. Makan means the shelter, right? Itself is a part of the basic need of human being, and these were not incorporated as a fundamental right. No, it has to say right to shelter should be there. One case is very famous, Chameli Singh versus State of UP case 1995. And under this, the Supreme Court interpreted right to shelter is one of the fundamental right under the Article 21 of the Constitution of India. And in order to fulfill this particular obligation, many initiatives have been taken place, but two important initiatives you have to quote in your answer sheet. The first important, Atal Mission for Rejuvenation and the Union Transformation, what is called Amrit, right? Amrit 2015. Under this particular mission, we have taken the decision that shelter should be given to privileged and unprivileged section of society. And very, very important, housing for all scheme. This was adopted by the state and then Pradhan Mantri Awas Yojana 2015. So this is the, house to all, very, very important aspect in order to maintain the right to shelter. This is nothing but expansion of Article 21, right to life, is concerned after the Maneka Gandhi case. Let us go for the next important, what is called right to end of the life choice. That is very, very important fact. We have to say right to live with dignity, then right to die with dignity also. One important aspect came into being under this one, right to end of life according to your choice, right? This is the one important case, Aruna Sandbach case 2011. Under this, the Supreme Court declared that right to die with dignity is also a part of the fundamental right. Right. And for this particular purpose, Supreme Court again has given the verdict in 2018 and has to say right to die with dignity itself is a part of the fundamental right under the provision of Article 21 of the Constitution. Right. And one thing is there, one is called passive euthanasia. Right. Euthanasia is said to be the one practice upon which whenever the person is very in the painful situation and wants to remove the ventilation or the other equipment that is going to give the life support, then and thereafter it may possible, and so this is called the passive euthanasia, right? So this is the automatically guaranteed. Earlier these were illegal in nature, now it has become the legal portion under the passive euthanasia. Active still it is a part of the illegality. And the last important, right to abortion, right? Right to abortion is going to happen under the Medical Termination of the Pregnancy Act, right? So earlier, this is called the Medical Termination of Pregnancy MTP Act. One is there, and based upon that, you are going to just make the process of abortion. But these were available only for the married women. Single women, it was not single mother, it was not automatically viable for this one. Like Supreme Court verdict came into being in 2022 and has to say yes, this is the right to make the abortion reproductive activity. So whether I have to keep children or not, this should be my choice, and this kind of choice must be maintained under the right to life. So based upon that, you have seen these automatically expansion has been taken place after expanding Article 21 of the Constitution. एक तरफ से अगर हम उल्टा बोले तो अगर एक्सपेंशन नहीं होता तो शायद हम इतना कुछ नहीं कर पाते. So this particular expansion has been taken place in order to make the progressive character of the social system, right? तो बच्चे तुम लोग समझ गए, इतने सारे इंफॉर्मेशन है रिलेटेड टू राइट टू लाइफ. Let us go for the, तो हमने क्या क्या डिस्कस किया? We have made the discussion under this one, the first important area, and this is the area is said to be the scope extension of the right to life. Now let us go for the scope extension of the right to personal liberty, right? So let us go for the next important area. This is called the personal liberty right, right ना? तो अब देखो इसमें right to life under the personal liberty, right? See, what happened in the personal liberty, right? After Maneka Gandhi case, many things came into being. Basically, 5 important areas I have taken that is said to be the very prominent after the expansion of Article 21 of the Constitution. The first is right to privacy as fundamental right. Right to privacy as fundamental right. Very, very important case, Justice Puttaswamy versus Union of India, case 2017. This is the very historical judgment, and it has to say the right to privacy as the fundamental right. Earlier, right to privacy was there, but it was the legal right, it was not the fundamental right. Kehar Singh case was there, and MP Sharma case of the 1954, Kehar Singh case of the 1962. Under these two cases, Supreme Court regarded right to privacy as legal right, not fundamental right. It means if there would have been violation of right to privacy at that particular time, first you have to go to subordinate court, then you have to go to the High Court, then you have to go to the Supreme Court. But after being the fundamental right, you can directly move to the Supreme Court. This has been taken place under the Puttaswamy case, and this is called the Article 21 is getting expanded for this interpretation, right? This is the Constitution Bench unanimously decision taken by the judges, and two important areas were highlighted under this one. This is called right to be forgotten and right to be left alone. Right to be forgotten, it means whenever the publicity of the information is going to happen, then I should have the right to delete the information from time to time. Earlier, it was going to happen that whenever you have to post certain information on Facebook, then there was no any button for removal of that particular information. So consider I have divorced my wife, and then and thereafter, I have married with another one, but my wife's previous wife photos are available on my Facebook. Still the person may troll me. Then we have to say no. आज के बाद से there should be right to be forgotten. Another important right to be left alone. Unnecessarily the social system is going to interfere in the life of others. It is not. This is our right to privacy, to be leave alone, right? Don't make me the pressure to do this one, that one. So automatically said to be these two automatically areas we incorporated in the legal system, right? Many legal laws, many legal public policies came into being. Second is called decriminalization of the offense under the section 377 of the IPC. Now IPC name is getting changed. So 377, homosexual, relation is said to be the part of the criminalization. The punishment was there for unnatural sex. But later on, under the Naj Foundation versus Government of NCT of Delhi case, 2009, Delhi High Court itself has to say that homosexuality is a part of the natural phenomenon and it should not be a part of the criminalization. There should be decriminalization of the cases. And later on, under the Navjot Singh Johar versus Union of India case 2018, both recent cases, and we have taken the decision that there should be complete decriminalization of section 377 of IPC. It means after this decision, we have favored the homosexuality, homosexual relationship, and legal character of homosexual relationship came into being. Ultimately, we are going to favor, we are going to support LGBT communities. That is said to be the neglected community later on, but we have given the approach of the LGBT community. You have seen also, after this particular, we have taken what is your sex, whether male or the female or the others, transgenders. So many transgenders earlier was not regarded as a part of sexual orientation, but sexual orientation has become a part of the freedom under this particular case. So we have seen second important development. Third development is related to right to have data security. So you should have the data security. Your data is there because under the information technology, many data are going to be the public. But who will maintain the security of the data? Under this particular, Aadhaar card protection case came into being in the 2016, later expanded in 2018, and has to say that Aadhaar card having the so much information of the person or the citizen, but it should not be used for the any purpose. There should be reasonable purpose for the use of the information from time to time, right? And next important, Justice B. N. Sri Krishna Committee came into being for the data security. It has given the very elaborated recommendations, and elaborated recommendation, even the certain institutional framework was recommended by Justice Balakrishna Committee, and it has to say that this is Justice Sri Krishna Committee has to say that there should be amendment in the Information Technology Act 2000, and we have amended recently. The Information Technology Act 2023 came into being, having the very great focus upon right to privacy, particularly related to the data security, right. Another important right against phone taps. Phone tapping itself is a part of, you have seen also recently. So Pegasus, so you have seen so many automatically said to be the some software, and government is going to use this one, that. So it has to say, one case was there of the 1997 very famous case, PUCL, People's Union of Civil Liberties versus Union of India case 1997. Under this, for the first time, the Supreme Court has to say phone tapping is nothing but violation of the right to privacy, and so it should not be done by any agency without having any reason. There was earlier the Telegraphic Act, that is the mentioned here also, Indian Telegraphic Act 1885. The 1885, there was the one section was there, section 5 clause 2. Under this was mentioned here कि for the certain purposes you have to tap the phone. If the person is under the investigation or investigation of the heinous crime, then and thereafter getting the approval from Ministry of Home Affairs, you have to make the tapping of the telephone. But later on, this was being misused, and so it was getting amended in 2007, and many provisions related to the right to privacy were incorporated under this particular right. And the last one, the right to have the choice of marriage. So one of the case, Safin Jahan case, right. Safin Jahan case, it is mentioned here, yes, right to choice by the marriage is the fundamental right. Love jihad type of system is going to happen, then it's okay. It is only oriented for the forced marriage, or the purpose of the marriage is not very holy or the sacred, then you have to take the decision. But under this one, if any person is going to make the choice, then a special marriage act must be amended in order to just promote such kind of the system, because it is related to the right to privacy. See, fundamental right, decriminalization means support of the homosexuality. Now, right to data security, against phone tapping, choice of the marriage, even the same-sex marriage is concerned, even the 2 out of the 5 judges are going to favor the same-sex marriage, although the 3% has to say this is not the fundamental right, and let us, the parliament has to take the decision about what should be done with the same-sex marriage, right. But still, if 2 judges are going to favor, it means having the some important orientation for the same-sex marriage. It is completely related to, this is the decriminalization of offences. We are going to accept the LGBT community as a part of the fundamental right. So friends, you have seen here, these would not have been taken place in India without having interference of the Supreme Court, after which case, that is Maneka Gandhi case 1978. Clear? So this is the basically the information you have. Once again, I would like to give you the so analysis here. That is what is the first is concerned. We have started our journey from this particular area. Content is concerned, and content, that is the very clear right to life. This is the content. Another important right to privacy. This is the content here. Right? Clear? Now, how would you like to say the writing the answer in the 150 words or the 250 words, depending upon your skill. So let us go for the discussion about the second important matter. This is the information very well. इससे ज़्यादा का information नहीं है अपने पास, right? अब देखो इसको how to mention here, how to write. Then second important area we will have to go for the discussion. This is called the answer presentation, right? So let us go for the answer presentation. How do you like to write this particular question appropriately, right? So this is the answer presentation is concerned, right? See, that is answer presentation is what? This is the, I am just giving you the answer presentation in this area, Locus is very clear, focus is very clear. You have to divide the answer into, I am giving the one important slide for the purpose of the discussion, Right answer. Answer should be explained into three important areas. One is called the introduction, one is called main body, right now, and another important is called what is called the concluding para, right? Conclusion you can say. Clear? Introduction is concerned. Introduction should have, that is, Article 21 must be mentioned in the introductory portion. Article 21 is getting extended, right? Extension is there, right? Extended. After which particular case? Maneka Gandhi case is concerned of the 1978, right? After inception of doctrine of due process of law, why? Because making our the system as progressive social system, progressive Indian society by constitutional dynamics. These are the core information that must be incorporated under introductory para, whatever your literature, depending upon your skill, right? You may write also, right? In order to create the progressive Indian society by constitutional dynamics, the inception of doctrine of due process of law under the Maneka Gandhi case 1978 extended Article 21 and that, or you can say Article 21 is extended with the incorporation of the Maneka Gandhi case something, whatever the literature you can write, but these are the core areas, core words must be mentioned in your introductory para. Article 21, Maneka Gandhi case, doctrine of due process of law, progressive Indian society and the constitutional dynamics. When the questions are being asked in the 250 words, then must be written under the 25 words or the maximum of the 30 words. If it is being asked in the 15, then you can automatically leave some of the important areas, must be incorporated under the 15 or the maximum of the 20 words. Each RM is your analysis, your skill of synthesis you can use for the introductory para. Right? Clear? I will tell you the core area. I will not give you the introduction. I will try to teach you, to mentoring you, to have to create your own introduction. Otherwise, there will be the copy and paste in everywhere. No, core must be there and literature will be your own part. Clear now? Now let us go for the main body is concerned. Main body is concerned. What is the main body? This is the main body area is there, right? So main is concerned what? Main body. Main body will describe this one. Main body will describe the two things what is the mentioned in the PPT. The first expansion of which one? Expansion of right to life. Under this how many points were there? 6 points were there, right? And all the 6 points is supplemented with illustrations, right? Illustration number 1, illustration number 2, illustration number 3, illustration number 4, so 5, illustration number 6, right? Just like right to dignified life, right to have the dignified life, live with dignity. Then what is the, references? References is what? That is called the Maneka Gandhi case. If we have to say references Maneka Gandhi case, another child labor is concerned. Are you getting or not? No. I am just giving you this one. What we have to make the discussion. This is the aspect and this is the illustration. Aspect, illustration. At least one illustration you have to write depending upon the space management. If the question is being asked in 150 words, then you have to take only one aspect. If the 250 words, 2 aspects you can take, right? I am just to make the discussion with the thinking the question may be asked later on. I am not telling you the perfect question. I am just giving you the crux about how to present the information. So let us go for the this one. And so where we had here, this is right to life, this is the aspect, this is illustration, aspect, illustration, illustration, illustration 3, illustration 4, 6 is concerned. Next important expansion of which particular? Right to privacy, right? The right to privacy, that has also means personal liberty. This is also related to 5 important area. Again, illustration 1, illustration number 2, illustration number 3, illustration number 4, illustration number 5, and you have to incorporate appropriately. Are you getting? This is the main body. So, depending upon your structure, consider you have to write in 150 words. Not the 6, you have to write only the 4, better. Or you have to minimize the literature, minimize the number of words, and you have to write the 6 important area. You have to mention in the point wise approach also, right? So depending upon your, what is the space given to you appropriately, right? You have to manage yourself. It requires the certain practice. It is not going to happen in one go, right? It requires the certain practice. Now let us go for the next important area, what is called the conclusion. Right, conclusion is concerned. So one is consider what is called the conclusion. I am just changing this one, and this is called the concluding para. Conclusion. Right. Friends, you know very well what is the meaning of conclusion. Conclusion means the way out. Right. Conclusion means the final crux. Final crux is what? Final crux is very, very important fact is there. This is the expansion, right? Expansion of 2 rights is there, right to life and right to what? Personal liberty. This has been taken place. Why? Because we want automatically said to be a state as what? Welfare state, right? We want welfare state. We want our state to be what? Modern positive state. Modern positive state, right? Another important, we have to favor what? Constitutional morality, right? This is called the constitutional morality concept is going to happen, right? For this particular purpose, this is being expanded, right? And these are particular fact. This is related to progressive social system, right? And based upon this one, we have to finish the conclusion, right? The conclusion means Article 21 must be there, expansion must be done. Justice itself is a dynamic concept, and whenever justice concept has to come, automatically it must be compensated through the expansion of Article 21. That's clear? So for this particular purpose, I would like to just, going to tell you bye, and then and thereafter, I will meet you in the next portion of the discussion, and if you feel any kind of the doubt related to the topic, then tell me. So you have to write either in the comment box. Even my number is, I think number is not available here. Na? So I am giving you the number. Here is the number is there, and so 9868 421 375. This is my WhatsApp number. You have to write the WhatsApp if you feel any kind of the doubt under the discussion. Same another question I will come to make the discussion, right? For that particular timing. Thank you very much for watching this one. So thank you. May God bless you. Bye bye.